September 18th, 2022, two families' worst nightmares were cemented into reality when they found out that the bodies found on Buckhorn Road in Efland were the missing teenagers Lyric Woods and Devin Clark. This case is about a choice that ended two futures. Three young people got together in the early morning hours of September 17th, and now two of them are dead. Now, the defendant chose to testify, and that's his right. But he is not a neutral witness. He is the only person in this courtroom with a personal stake in your verdict. He has every reason to explain, to minimize, to justify. He told you what he needs you to believe, not what the physical evidence proves. And when his words conflict with the physical evidence, you are not required to accept his version. Stories can be shaped. Evidence cannot. And from the defendant's perspective, he has to somehow justify two killings, or he has to completely absolve himself of responsibility for one of them. It would be nearly impossible to justify those two close-range shots to Lyric's neck as being necessary in self-defense. But by saying Devin shot Lyric, he eliminates all possible responsibility for her death. And he puts in your minds that Devin was a threat to him, thereby justifying killing Devin in self-defense. Now, that's a tidy argument if it was supported by the other evidence in the case, but it's not. First, the defendant claims that the first set of shots testified to by James Rogers was Devin shooting Lyric, and then the second set of shots was the defendant shooting Devin. Mr. Rogers testified that he was woken up by a noise, fireworks, or gunshots. He wasn't 100% sure. And then 10 minutes later, he heard 4, not 5, distinct gunshots. We know from the evidence that Devin was shot 6 times, not 4 times. Now, I'm no mathematician, but even I know that's not adding up. The defendant's testimony also does not account for that 10-minute gap at all. He says everything happened so quickly, but that can't be right. Now, the defendant also testified that he threw all of Devin's belongings out of the car on the side of Buckhorn Road on the way to the Petro. But there are a few reasons why we know that can't be true. On the cash report, Devin has 61 timing advance records between 1:45 a.m. and 2:42 a.m. Roughly 1 per minute. And this block down here. And his phone never leaves the scene. All of those records are a consistent distance from this tower, and the timing advance bands go right over the top of the crime scene. And the last time Devin's phone connects to the network is at 2:44 a.m. The defendant's phone, on the other hand, is on the scene from 1:45 a.m. to 2:14 a.m., and then it travels, and he heads to the Petro. And we know he's at the Petro from 2:20 to 2:29 a.m. Remember, the Petro video shows him approaching the cashier, and he's holding his phone in his hand. And the Petro video says this is from 2:11 to 2:19, but obviously that's 10 minutes slow because this timing is going to be the most accurate timing. And we know he's there. He's on video. Now, he returns to the scene at 2:36 a.m. And he's there until 2:50 a.m. Now, that encompasses the time frame that Devin's phone suddenly disconnects from the network. Additionally, Devin's vape, this vape that we keep hearing about. The defendant said on cross-examination this morning that that vape was in his pocket and and that he threw it out with the rest of Devin's belongings. But the medical examiner testified, and it's in her report, that in the clothing and personal effects section, Devin's body was clad in tan pants, 2 black socks, black underpants, a black and white long sleeve hoodie and underlying white t-shirt. A vaping device is in the pants pocket. So if the defendant wasn't in possession of Devin's vape, Devin was in possession of Devin's vape. When did that happen? The defendant also testified that he moved Devin's body before heading to the Petro. He specifically said that Devin had fallen face down near the edge of the gravel, and that he took off his camo jacket, removed his black quarter zip, used the quarter zip to flip Devin over so that he was face up, and then dragged him so he was completely out of the road. Now the evidence shows that Devin lay bleeding face down for some period of time before he was turned over, and that he was right next to Lyric when this happened. Remember the crime scene photos, and we discussed the 2 large pools of blood that you can see in between the bodies, depicted here by Lyric's hip and here by her foot. Now imagine you took Devin and you rolled him over onto his face toward Lyric. Those 2 pools of blood would line up exactly with the thigh wound and with the wound to his shoulder. You rolled him over face down right there, that's where he's going to be bleeding. And because those pools of blood are so large, we know he had to have been left there for some time for that to accumulate. And remember also the dusty, dirty spots on his clothing, which were inconsistent with how he was found. Now, it took approximately 20 minutes for the defendant to drive to the Petro, get the gas, and then come back to the scene. And that would explain why those 2 areas of blood exist when they don't match up with any other injuries on either Lyric or Devin. The defendant also testified that he returned to the scene after leaving the Petro to retrieve his black quarter zip that he used to move Devin's body. Members of the jury, the defendant's wearing a black quarter zip at the Petro. You can see it here underneath the camo jacket. It's a little fuzzy, but you can see this shine right here in the center of the neck, and you can just barely see right there a lighter spot where that zipper would end. So you can't have left it at the crime scene, which means he didn't use it to move Devin's body, which means there must be some other explanation for all of this. In jury selection, you describe some things that are important to you in determining the credibility of a witness and what weight to give their testimony. You describe things like whether they have provided consistent statements, whether they have an agenda, whether their story matches or lines up with other evidence, and also a person's demeanor and body language. Now, this is supposedly one of the most horrible things that's ever happened to the defendant, but his affect and delivery in this courtroom was completely flat. There was no emotion at all. The defendant failed all of the tests that you described, that you use in your everyday lives to assess someone's credibility. So now that we know that the defendant's story is a fabrication, the question remains, what exactly did happen in the early morning hours of September 17th? So let's talk about Christian. Issiah was not a suspect before Christian came forward. The sheriff's office had not yet uncovered any evidence connecting the defendant to the offense. Christian did not know his interview was being recorded, and he wished to remain anonymous. And it was pretty obvious that he did not want to be here testifying. So if Christian isn't being honest about his conversation, then he just, out of the blue, decided to implicate someone that he has a casual friendship with in a gruesome double homicide. He could have easily told the deputies when they called him that he didn't have any information and kept himself completely out of it. So why come forward unless the information is true? Issiah's testimony about his relationship with Christian contradicts itself. Yesterday on direct examination, he said that he and Thomas, Christian's cousin, had a falling out, but that he and Christian kept hanging out after that. That Christian would pick him up from work and give him rides, and he described that. And today, he told you that he fell out with both of them at the same time, and that he had not spoken to Christian until Christian contacted him on that Sunday the 18th. In his testimony, Issiah did not tell you what he told Christian. He said he gave him a brief description, that it was not a complete recitation, that he told him what actually took place, but that he can't really say what he said to Christian. The version that the defendant told Christian is more plausible than what you heard from him on the stand. Issiah told Christian that I capped them, that they were both going to have sex with Lyric, but he didn't provide any details about what happened when they arrived to the scene. Then he said that Devin was beaming him with a gun. He told him to stop doing that once, twice, and on the third time, he was upset enough about it to try to wrestle the gun away from Devin. That the gun went off between his legs, that he got control of the gun and shot Devin, and then he turned around and shot Lyric because she was a witness. Now, Christian testified that he assumed that this occurred in a vehicle because of the phrase turned around, and also stated on the stand, on cross-examination, that Issiah never told him it happened in the car. That's just what he assumed. Now, turn around could mean a lot of things. I mean, if I'm facing this direction and I turn to face this direction, then I've turned around. And there's no evidence that there were any shots fired in the car. So although that was one assumption he made, he didn't actually say that that's what the defendant told him. Now, Christian also described that they had this conversation over video chat on Snapchat. And he said that Issiah was outside at his stepdad's house when this happened, which is consistent with where Issiah was on Sunday. He was at Antoine's house, and Antoine testified that he spent most of the day outside. And also remember how Christian described the defendant's demeanor. He was laughing, that he was joking. He didn't seem to have any remorse at all, while relating that he had just killed 2 people. And he told Christian all of this without prompting and before their bodies had ever been discovered. Now, it's equally important what he does not tell Christian. He doesn't say, I was scared for my life. He doesn't say, I was threatened. He doesn't say, I had no choice. He doesn't say it was either them or me. And he does not say that Devin shot Lyric. And Issiah confirmed that for you in his testimony. He did not tell Christian that Devin shot Lyric. Now, the version of events that Issiah told Christian bears almost no resemblance to his testimony at this trial. One of these statements was made within 48 hours of the events happening. One was made over 3 years later, after he's had an opportunity to review all of the evidence collected by law enforcement and hear all of the evidence presented in this courtroom. Which one is more likely to be closer to the truth? So, what does the evidence show us? The evidence shows that Devin and Lyric did have sex, or at least engaged in some kind of sexual contact. Lyric's oral swabs, her underwear, and her external genitalia swabs show both her and Devin's DNA. Devin's underwear and his external genitalia swabs show both his and Lyric's DNA. So something happened between them, most likely exactly what was discussed in the messages, oral sex. Now, the evidence shows that Devin was offering for whoever was going to give him a ride to have sex with Lyric. But there's no evidence that Lyric was aware of that promise, or that she agreed to it. The defendant gave a ride under the impression that he would have a turn. Perhaps this is what sparked the disagreement. Lyric and Devin finished what they were doing. The defendant stepped up, expecting his turn, and Lyric balked because that is not what she signed up for. Now, it's possible that Lyric did say what the defendant said, that she told Devin she wasn't a whore, and she wasn't going to let Devin pimp her around. What if those statements were in reference to not having sex with the defendant? We can't know for sure. You know, there's this TV show on Netflix called Black Mirror. I don't know if any of you have seen it. But it's about the interesting intersections between technology and our real lives. In one episode, there's an implant that you can get that'll record every single thing that happens to you. Or kind of like those red flag replay commercials during football games, where you can just relive an event exactly as it happened. Well, we don't have that luxury. We don't have that technology. So we can't know for sure what happened. But something sparked the disagreement, such that a gun was introduced to this situation. We also can't know for sure who brought the gun or who introduced it to the conflict. That is not a knowable fact. What we do know is that the defendant walks away without a scratch, and that Devin and Lyric end up dead. Now, how could this have happened? How could this have happened? If we look at the crime scene photos, we sort of have three distinct areas. Shell casings down here that were marked 1, 2, and 3 by the sheriff's office. You know, there's no blood surrounding those rocks or anywhere near them. Perhaps those were the first shots fired. So we have 3 shots, and maybe we assume that those are the body shots that are front to back. So that would be Devin's right shoulder, Lyric's left arm just above the elbow, and Lyric's left shoulder that entered at an angle and then exited her upper arm, as if she were turning away from the person who was shooting. Now, if those injuries occurred next to the GMC on that front passenger side, that could explain her blood on that fender and the rim there. Now, both begin to move away, and they are moving up the scene toward where we have this row of placards back here, 7, 4, 18, 5. There are 5 shell casings found along that same path right there. Placards 4, 5, 6, 7, and then the one found the following day by investigator Vila, which he described as being over here just on the edge of this brushy area near where the red slides were located. Now, somewhere over here to the left, near placard 7, is where Devin receives his foot injury. And that shot was also slightly front to back, according to the medical examiner. So imagine he's moving away from where 1, 2, and 3 are. He's moving toward where 7 and 4 are. And then he realizes he's going to run into all this thick brush here. And so he has to change direction. He could have easily gotten that foot shot during that process. And that is consistent with the blood. It starts out just a little bit here by placard 18, and it gets thicker and more frequent as we move along the scene from left to right towards placard 8 and 9, which were those other rocks with the blood on them. He loses his shoes in that tall clump of grass just beside placard 9 where all this blood is going. And then we've got the shoes here in the brush. Maybe he's urging Lyric along ahead of him. The defendant's still shooting them from behind as they make their way toward that open field. Both are hit enough times that they fall. They're unable to keep going from their injuries. Now, if you're keeping count, that's 8 shell casings. So here's the break that Mr. Rogers described. don't appear to be getting back up, then there's a break in the action as the defendant tries to figure out his next steps. Because now he's in big trouble. He can't afford to leave them alive. And that's the conclusion he reaches in those 10 minutes. And so then we have the 4 shots that Mr. Rogers described here. Those distinct 4 were the insurance shots to make sure that they are dead. And those are the casings that were found in the grass near Lyric's head, originally marked as 12, 13, and 14, and then upon a second examination, number 20 was also located. Right here, just above where both bodies are found. Those shots are the 2 in Lyric's neck, the 1 in the back of Devin's head, and either entrance wound 1 or entrance wound 2 for Devin. Those are the 2 injuries. 1 came through the front of his neck, severed his jugular and carotid arteries, and 1 entered the back of his shoulder, and that's where that projectile stopped, just above his collarbone. The defendant cannot claim self-defense with regard to the death of Lyric Woods because he claims he did not shoot her at all. But the defendant has argued that he acted in self-defense with regard to Devin Clark. Self-defense requires that the defendant believe it was necessary to use deadly force against the victim in order to save the defendant from death or great bodily harm. It also requires that the circumstances as they appeared to the defendant at the time were sufficient to create such a belief in the mind of a person of ordinary firmness, or put another way, that the defendant's belief was reasonable, and that the defendant did not use excessive force. The backs of these victims tell you everything that you need to know. Fear runs away. It does not give chase. It is consistent with the evidence that the victims were moving away when they were being shot at. Both of them have multiple gunshot wounds to the back. Now, our courts have said that it is entirely unreasonable that a person of ordinary firmness would have considered the use of deadly force necessary to protect himself from an unarmed person who was running away from the scene. Once the gun is in the defendant's hands, there is no longer any danger to him, if there ever was any danger to begin with. Once the gun is in his control, he can leave. He can call for help. But he doesn't do either of those things. Instead, he chases down Devin and Lyric. Then, after 10 minutes of consideration, he shoots Lyric and Devin while they lie on the ground, bleeding from the wounds he has already inflicted. This was not one shot fired in panic. Panic does not aim, and chaos does not explain accuracy. This was a series of choices. The choice to pull the trigger a second time, a third, a fourth, and a fifth, and a sixth, and a seventh, and an eighth. And then it's especially the 9th, 10th, 11th, and 12th. Shot after shot, decision after decision. Now, once he can be sure that they're dead, the defendant does leave the scene. He goes to the petro and puts gas in the car, and he still doesn't call for help. Then he returns to the scene, and why? Because Devin's phone is still there, and it contains evidence. So he had to go get it. To accomplish this, he had to move Devin's body, because Devin was face down, and his phone was in that front pants pocket. Now you can see in the photographs how Devin's front pocket is saturated in blood from that thigh wound. Remember the luminol reaction over the dome light in the car that appeared to be a handprint that was cleaned? Now we didn't have any confirmatory testing on that, but if it was cleaned, that's not necessarily unexpected. So imagine he fishes the phone out of Devin's bloody pocket, and then when he gets back in the car, he sticks his hand up there to cover that light to make sure he's not seen. The wicked flee when no man pursues. With Devin's phone secured, the defendant leaves, and the cover-up begins. He disposes of evidence. Devin's phone and the murder weapon have never been located. He covers his tracks with the messages in the group chat. First, that same night, he messages that he was asleep and couldn't get his mother's car to use, which by his own admission were untrue. Second, throughout the weekend, he's responding to messages about Devin being missing and then Devin being dead, as if he didn't know exactly what had happened to him. And then third, he makes arrangements to leave the state and he flees. It takes until October 5th for law enforcement to find him. 15 days between charges being taken out and his arrest. Now, the defendant was young, only 17 at the time of the offense. And while youth may explain immaturity, it does not excuse violence. At 17, the defendant was old enough to understand what a gun does. He was old enough to understand that pulling the trigger ends lives, and he was old enough to stop. His age does not change what happened, and it does not change your duty. In a few moments, the judge will instruct you on the law you must apply. For first-degree murder, the law requires the state to prove the following: that the defendant intentionally and with malice killed the victim, that the defendant's act was the proximate cause of the victim's death, that the defendant intended to kill the victim, and that the defendant acted with premeditation and deliberation. Malice means without just cause, excuse, or justification. Premeditation simply means the intent to kill was formed before the act. The law does not require a long time. In fact, mere seconds can suffice, as long as there was time to think. Deliberation means the act was carried out in a cool state of mind, not under a sudden, overwhelming passion. And you'll be instructed that you can infer premeditation and deliberation from the following circumstances: the lack of provocation by the victim, the conduct of the defendant before, during, and after the killing, the use of grossly excessive force, the infliction of lethal wounds after the victim is felled, the brutal or vicious circumstances of the killing, and the manner in which or means by which the killing was done. When you apply North Carolina's definition of first-degree murder to these facts, the conclusion is unavoidable. This was an intentional killing. There can be no other conclusion given the number of shots fired. It was done with malice, that is, without just cause, excuse, or justification. And premeditation and deliberation are shown by the repeated shots to the back, the additional shots fired after the victims had already fallen, and the defendant's conduct after the killing in trying to hide his responsibility. Under the instructions you'll receive, this was a first-degree murder. Each trigger pull, a separate decision to end a life. A 10-minute break in the action. Time to call for help. Who knows, that could have potentially saved the lives of Devin Clark and Lyric Woods. Carefully considered decision to fire 4 more shots, silencing them forever. Stories change, evidence doesn't. The backs of these victims tell you everything you need to know. The wicked flee when no man pursues. 2 lives were ended. 2 families changed forever. They'll never graduate, they'll never grow older, and they'll never come home again. This courtroom is the only place where their voices can still be heard. The evidence is spoken, and now the law asks you to respond. Hold the defendant accountable for the choices he made and the lives he took. Return verdicts of guilty. Thank you.